Good morning. My name is Karen Harding and I'm a criminal defence lawyer from Auckland, New Zealand. I'd like to welcome you today to our legal conference and CPD for New Zealand lawyers. In our first video today, we're covering the sexual violence pilot court and just going over some of the matters that relate to that. So the sexual violence court has been running in Auckland and Whangarei since December 2016 for serious Category 3 sexual violence cases that are to be heard before a jury. It started as a pilot and it has now become like a permanent fixture of most courts. The report on the evaluation of the sexual violence court showed that it was successful in reducing pre-trial delays and improving the court experience for participants. So there is guidelines put out. So we have here the guidelines here from the court of the sexual violence court pilot, guidelines for best practice, and the whole purpose of the sexual violence court is to improve case and trial management for the offences involving sexual violence. And they operate completely within the existing jury trial experience under the Criminal Procedure Act and the Criminal Procedure Rules and trial management techniques. But the guidelines produced for the sexual violence court are designed to reduce pre-trial delay, to ensure flexible trial arrangements, and they have been resulting in defendants being able to get firm fixture trials and to progress their cases so that they're not drawn out, and to be able to get them in a quicker time frame with priority. So that has reduced delays down to getting the trials down to about 12 months. Okay, so we now have a new entrance to our seminar today. We have Mr. Eastwood, who's come in. Want to sit here? Okay, so this is our first video. We're talking about the sexual violence court, and we've just been talking about the procedures for best practice. We've evaluated the court. It's been running in the Auckland District Court and the Whangarei District Court for serious sexual offences for Category 3 for cases to be heard by a jury. So just repeating what we've just talked about. It's just within the normal traditional jury trial practice rules of the Criminal Procedure Act and the Criminal Procedure Rules and trial management techniques. But the whole aim of the sexual violence court is to reduce pre-trial delay, to ensure flexible trial arrangements, and enable defendants to get firm trial fixtures, and so that they're not undergoing too much stress. And also the complainants have also found in evaluation that their stress levels have been reduced as well. So there are dedicated judges who have had training to do sexual violence pilot court. So all cases in the court are dealt with by a judge at the case review stage. All defendants must be present at the case review hearing unless their attendance has been specifically excused. The Crown and the defence must engage in case management discussions and jointly complete the case management memorandum. Okay, I think that's the same as normal, but a sort of a special memorandum has been developed that covers things in more detail. So your CMM covers the matters set out in Section 56 of the Act and Rule 4.8 of the rules, and I'm also going to attach the summary of facts. The judges have the power to order costs against lawyers if there are procedural failures under Section 364 of the Act. So if you don't get your act together when you're in the sexual violence court to do your CMMs, then some nasty things might happen.
Can I ask a question?
Yes, would you like to come around and be on the screen?
I can be off screen, but just the Criminal Procedure Act.
Yes. That's the Act, and it also has some rules, and the courts developed some guidelines, and they have it here called the Sexual Violence Court Guidelines for Best Practice, and we'll start to talk about those as you joined our conference today. So it has been a pilot, it's been very successful. The judges have had sort of special training. The aim is to reduce pre-trial delay. So you want to identify at the early stage of your case review stage. If you want to come in here, then you can be on camera. At the early stage of the case review stage, you want to identify really what the issues are. So if you have disclosure issues, or there's been non-disclosure by a non-party, and you want disclosure from a non-party, and maybe you want, various reports from people that with the police, from government agencies, then you want to identify those so that you've got them sorted out quite early. If there's issues of joinder of other charges or other defendants that should be in the trial, if it's a multi-accused murder, you want to deal with those issues. The issue, of course, of alternative ways of giving evidence. That's about the use of the screens or AVL or the audio-visual lenses, that is what AVL is, and how the components might give evidence. And also you could have overseas witness that might have to give witnesses by an audio-visual link, because some of the sexual violence cases are of course historical, and then you might want to go back and get disclosure from a non-party. So you might need to go back and get those old SIPS records or old records held by the police from social workers or counsellors or psychologists, medical records, or even if there's, for example, if in a historical case they've described the layout of a house in terms of where the bedrooms were and different things that happened, you might want to sort of go and look at that information as well. That might not necessarily be with a non-party, but you want to sort that out, because that could be relevant to credibility and other things, to locate those records or plans, that kind of thing.
Just one thing, the sexual violence court, is this a pilot just for Auckland, or is this rolled out nationwide?
No, it's in the Auckland District Court, and it's in Whangarei. It's been in Whangarei as well.
I can just say two courts.
I appeared myself in the Auckland District Court Sexual Violence Court when it was the pilot. I can say that actually it was really constructive process, and the previous experience was that the trials can go on and on. You just to get the trial fixed through. Before the sexual violence court, I had a case, someone standing charged for sexual violation. It took 3 years to get the trial with all the various things that went wrong and to aborted trials and things. But in the last case I had, they had the fixture set straight away, and so I would have had a trial fixture within 12 months. And our case was able to resolve in the pre-trial hearings, and that was because there was so much pressure put on everybody to identify all the pre-trial issues, and within the pre-trials, and it resulted in a successful outcome for our defendant because they were identified. Because they put pressure on counsel to do the work.
They're trying to fast track it rather than have these things hanging around for years where you've got a complainant and you've got a defendant. So you're bringing quicker resolution.
That's right. And so the case that I had in the pilot court came out of the Waitakere. So he was charged for a sexual violation incident that happened in Waitakere. And then as soon as he entered the not guilty plea in the registrar's list, rather than having the case hang around in the Waitakere District Court going for case reviews and other things, it went straight to the Auckland District Court into a Crown case review. In that case, there was a lot of dragging of heels about giving the disclosure, because there was trouble to get the complainant to do a video interview, and the disclosure didn't come, and then in the end those charges ended up not being able to proceed for trial because that never happened. She was never able to do her video or to get a proper statement going. So that is quite interesting, that you really are forced to identify things quite early. I think that's really helpful for the lawyers, because you get the flow, your client's really interested to make progress on his case, got to strike while the iron's hot, you're doing things within quite a tight time frame. Really the disclosure comes quite quickly, so that you have quite enough information, and you certainly know what other disclosure that you need, and then you can really make a big deal if you don't get that disclosure. And it gives you an opportunity to think about those other parties that you might want to get disclosure from if you want the old SIPS records. And then you want to think about how the parties are going to give evidence, which is certainly relevant for the children. There's not often a lot of issue from a defence perspective and how the children are going to give evidence. I certainly don't have any trouble with them giving evidence in the usual way in the other room over the audio visual link from the back, and having a support person with them, and indeed when they're comfortable that kids can say all sorts of things which can be of interest. So you want to also then be looking at it at an early stage what your admissibility of evidence is, whether there's a bunch of produce propensity evidence. Also you might want to be looking at any video statement that your client might have made and whether that needs to be reduced in length or have some sort of edits done to it. Also the need for interpreters. That's like a really big issue. I've done back in the old days in Otahu District Court, I had a Chinese man for a rape trial, and the interpreter just stopped translating during a big chunk of it, and they were sort of behind you, and they just stopped, and then they tried to say, well, have you been translating? And no, and then they had to read back half a day's evidence. So you want to be on top of the situation, because if your client doesn't speak any English at all, you're completely relying on the interpreter, and if you've got multiple accused, that's also tricky too, because it's the old way. They don't have the little earphones in the ears like they do at the United Nation. It relies on somebody verbally translating every word, and then you've got to control how the witnesses and the questioner are delivering the speed of it so it can be translated. We recently had a case involving also sexual violence involving 30 fishermen, and I had Indonesian fishermen in court and the translator, and you just got to go at the speed that they can be translated so they can be empowered to participate, because you can't disempower your person by the fact that they don't know what's going on because they've heard nothing, because they can't give you instructions. So it's got to go at the right pace. So you've got to identify the interpreters early, because what that means is your trial's going to take longer. Because if you thought that it would be like a 3-day sexual violation trial, is sort of just one complainant, just a few witnesses or whatever, you're just going to realise it's going to take double the length, because it's going to have to go slower so it can be translated. If you don't do the translations properly, you've kneecapped your client and you've created unfairness.
A general question though, what about the desirability of sexual violence court? Specialist courts. Is that a good development where we should have lots of little specialist courts?
I personally felt so, because in my previous experience, that, like, for example, that case that went on for 3 years, and then there were these various issues that came up, that was quite painful and stressful for the client. He could hardly move on with his life in really strict bail conditions. So you've got to remember that your clients might be on really strict bail conditions, and 2 or 3 year periods are a long time. Whereas in the other case that was in the pilot, it had a firm fixture, so instead of standbys, because for the other trials we were given standbys. And you know what standbys like, don't really stress. You have ready to go, you have your witnesses in, you're sitting in, and nothing.
I might argue though, why should especially sexual violation cases get a fast track, and people that have been beaten up by the neighbour that wasn't sexual but GBH should just be a standard, or you just go in the ordinary court, and sexual violence gets a specialist court? Should we have a little court that's involved with violence against neighbours courts, or where does it all end?
Well, I think that there's real benefits for having some specialisations and moving things around, because it frees up the list. So that everybody, you get your drink drivers who try to drag out their judge-alone trial so they can avoid having to lose their licence. But when you're dragging your case out for the inevitable, because you're worried you're going to get convicted, but then if you do that, you're going to get a longer sentence if you go for a jury trial, because there's no discounts. I mean, you get a 25% discount if you plead guilty early. So you basically, if you're going to jury trial, you're saying you're not guilty and you have a defence. So you want to plan for that, and you want to progress your life. I mean, if someone's on their bail conditions, you know, their 24-hour curfews or something, and got them on it for years, it's not good. So if you take the sexual violence and they're running pretty much, so basically they're having sort of dedicated courtroom to progress those things, it will lessen the list in the other room. You could also make a list, I suppose, if they wanted to run the fraud cases on another list, because they clog up the court. So you could run drugs on another list. Why not?
We have a specialist fraud court, specialist drugs court, specialist.
If there was enough, we're going a little bit off track of the start of the seminar, because we're still going through the guidelines, but if it helps make things work, why not? Because we specialise in different things. You get someone who knows about it, you're moving things along. And we've learned that from, you know, the fact that...
Can I make observation that I think... One of the observations of sexual violence court is really to progress cases for victims, so they don't have to hang around and do... Is that fair? More for victims than for defendants.
Have you had a case in the sexual violence court?
Yeah, normally it probably was, yes. Yeah.
Well, I can say from my experience, it helped us immensely. My person, you know, it's another case, but the case I'm thinking of, he had a job, and he had bail conditions. He was extremely stressed. And of course he's got to pay the legal fees because he was not on legal aid, so he doesn't want it to go on forever. He wants to make a timeline. He had immigration issues. He's going to have to renew work permits, visas and different things. He's also trying to have an arranged marriage and bring somebody in. So he actually had things he needed to tidy up his life, and having something go on and on wasn't good for him. Actually, it helped us because it was a kind of a recent complaint, or historical, because the victim, alleged victim, had called the police that night, so that he had got arrested that night, and she was alleging like a break-in, stranger rape, but actually they had met on social media and she had invited him round, and it was really a bunch of lies, and then she didn't say any of that, and then we were able to establish that from the messages from the social media stuff, actually he had been invited. And then the trouble with that one was that she didn't do the video. And then we had the extra complications that she was underage, so she turned out to be 15 years, 6 months and 30 days. So you didn't give consent at 16. I mean, that opened up these other defences under the Act, because there's a 3-step thing that you have to look at. So for our perspective on that case, with a private client, immigration issues, also trying to get married and bring somebody in on active charges on bail, for him it was really good to know that he had a firm fixture. And I think that's the benefit of it, to have a firm fixture. And for lawyers, to have a firm fixture, you can write them in your diary.
Is that one of the features?
Yeah, that's one of the features that I really liked.
Well, nothing's firm under COVID. Someone said to me, the judge said to me a week ago, it is a firm, but it's a coded firm, so sometimes...
Well, I mean, obviously, if we suddenly go into a level 3 or level 4 coded area, then we can't have the jury trials. However, saying that, Judge made us do the pre-trial applications in the sexual violence court on level 3.
Okay.
So it was all on, and we were running the pre-trials and we were writing submissions, and it was the first level 3 as well. And not a hand sanitizer in sight. It was quite kind of stressful. Not the case, but the worry about the pandemic. So it really pushed things along, and it put the Crown under pressure actually to get, because we had a whole lot of these disclosure issues, and it put the Crown under pressure, because all of a sudden the trial was due to start in August. We're doing the pre-trials in May, I think, in the first laboratory, and they'd missed some deadlines because of the COVID. The firm trial was set, and the court were vacating it, and they had to deliver, and they couldn't. So in that regard, for the defendant, it was really quite helpful. So anyway, so that's just sort of talking about that, and going back to what we were talking about. So we want to identify support people, because you're allowed to support people, and we want to identify your expert evidence. So you might want to have forensic evidence or expert reports, medical reports, psychologists give evidence, different things you might want to give expert evidence about.
Next question, sexual violence, you've mainly been called category 3, serious sexual offending. What about sexual violence? Is a bit of a loaded word these days. It could actually mean
there's a list, Peter.
There's a list here.
Yeah, there's a list of what all the charges are under the Crimes Act. There's a 3-page list of what all the charges are.
What about indecent assault? Is that a sexual violence? But does that come under the Act? Indecent assault, for example? Or?
Yes. So in relation to that question, does indecent act with a boy 12 to 16 years, indecent act to a boy over 16, indecent assault to a girl over 16, female indecent assault to a girl 12 to 16, over 16, over 12, sexual exploitation of significant impairment, attempted sexual exploitation, doesn't indecent act on a person or female, compelling act with an animal, sexual conduct, allowing to procure the young person to meet sexual goals. I've done some sexual goals.
These all come under the sexual violence court.
There's a list.
Okay.
It just goes on and on and on.
What happened? We had a case recently.
So it's all the usual cases.
A recent case that was in one of the men described as sexual violence was bumped up to the High Court. Today, what happens there if you decide to lift it over the High Court? You no longer have the sexual violence court. Or do the High Court operate with the same principles? Probably not.
Well, the sexual violence court is at the Auckland District Court, and the one Road District Court.
So the High Court.
High Court doesn't have it. But they are quite streamlined for the dates that they give for trial too. And they will make defence lawyers work hard and not want their cases to waft on and on. So for the sexual cases that we've done in the High Court, I mean, you just got to do your work. So
Is there a discretion about it? There's no discretion. Can the judge...
It's something to be a protocol offence, Peter, so you need to identify that in your case management memorandum. So there are some offenders that may be liable to preventative detention, and that might be, they have previous, for example, serious previous, so that might be appropriate to go to the High Court. So you've got to, actually that's one of the things that so when you get a case that is going in a sexual violence court, you want to get out these guidelines for best practice, which will answer because one of those issues is that you've got to look at in your case review memorandum where it's a case falling into the trial protocol that could be referred to the High Court and have those decisions made, and then they'll take the serious cases, won't they, and send the other ones back. Then of course you've got your trial court over, and the judge...
The sexual violence only applies really to jury trials, is that what you're saying?
Yes, it's for the management of the jury trial.
So it is a jury trial. So if you're dealing with something in the Auckland District Court where someone just elects to plead guilty, or a judge alone, they won't get into the specialist court action. So in that regard, if you plead guilty, so if you were going to plead guilty early, so after your first, say on the first appearance or after a remand without plea, you would have got into the sexual violence court. But if you entered the not guilty plea and you went to the case review, then you're in it, aren't you? And when you plead guilty, you're going to get allocated to a judge. Right. Well, they're nominated judges, are they?
Yeah, because you'll be if you ended up in the case review, you're in the parliament. Not your client.
I'm not your client. I won't be talking to your client. Okay. Let's clarify the point.
You know me. If your client was guilty, then
that's right.
Then they might, end up with, well, the judge might have read the file and keep it.
Well, they do. I mean, things in other courts don't get referred to Auckland necessarily. Although we get...
No, well, the one I was at came from Waitaki. Honestly, I actually thought it was really great because it achieved justice. Because I think in our case,
did you get convicted or
no?
What was the justice that this code got?
Well, it all disappeared.
I went away. It ended up discharged.
Yeah, so
147 or what was the 347?
Well, you know, so
right.
Yeah, so
you did a seminar on that?
I could actually do a secret seminar on the odd little charge that we had and the defence on
that. If you're in the sexual
it was pretty serious. It was fast. But we don't want to make a seminar about one case, so we're trying to just... So I would say that from our experience, that it put so much pressure on the Crown to deal with these disclosure issues, and they couldn't overcome the disclosure issues. They would probably have not overcome it and we would have been at the trial date.
Okay. So you
and the judges weren't like sympathetic of the defendant or anything.
So what are they to the prosecution case, is that what you're saying?
Yes. And then, and it was a complicated little case because she said that we left him off, Peter. But then she's saying that she's been, raped by a stranger who's come in the door and bound her up with twine and a bunch of that, and that never happened. And we were able to establish that just off our own evidence. But then it turned out she was underage. As we said, she was 15 years and a half and 3 days. So then we were wanting to run a technical defence about dealing with that. So that was quite complicated. So one of the issues is that they have to bring the girl to court, and then the judge was saying, well, they could still perhaps do the trial without the complainant. So it was actually quite complicated, but we had various hearings on it, and a lot of pressure went on both counsel by the judge to resolve this case. And it got resolved so that the case was over for my client, so my client was happy. So I think that in the normal court, that where there's so many cases and so much pressure on the system, you don't get that tunnel vision of putting pressure on you faster. So, I mean, my philosophy though is do the work, get it done, start early when everyone's interested in doing the preparation. We're all a bit different, maybe you want to do it last minute, but I like to do it early.
Yeah, well, I don't say that, but I mean, everyone talks, even Shakespeare used to talk about the wars delay and how things go goes back 500 years. It's not new. On the other hand, you can have McDonald's justice where it's dispensed on the day, they'll pull the money back. You get your burger.
It doesn't work like that because this is all really what the sexual violence court is doing. Is getting the lawyer to do the preparation. So it's about the preparation. What is the evidence? Have you got the information that you need for the case? Do you have the interpreters? Have you got, how are you going to run the evidence? What are your pre-trial applications? And we have a lot of pre-trial applications in ours, and that was really important to get decisions on those, because the decisions of those affected how the Crown was going to run things and affected how the defence was going to run things. And a lot of times, sometimes in the main courts, counsel roll up and try to do their pre-trials on the day of the trial starting, and the jury sitting out the back room just sort of waiting around or seeing what happened or what. So I think get it done and get it early.
What about open justice? What's the principle about the sexual violence courts about open justice? Do they like to have closed courts? Do you know what the principle is there?
Well,
there's a lot of closed courts going on. I'm not saying it's secret justice or anything, but there's probably good reasons for having closed courts. I mean, these people are very vulnerable and upset. But is that one of the principles of the new sexual violence courts?
No, under the current rules, the same applies everywhere, that when the alleged victim complainant gives evidence of a sexual nature, the court's closed for that, and then the court's open again for the defendant and the other witnesses to give evidence. And that's standard across all the courts for how they
But what are you saying about the sexual violence courts? The need to get disclosure, need to get pre-trials. I mean, it's the same principle in every trial, isn't it?
Yeah, all it's doing is making you do the work.
Yeah, okay.
Really,
Yeah, okay.
so that you can resolve the case efficiently. You have the distressed victim, but you're a defendant. Don't forget him, she's distressed too. My client was distressed, he wanted to, well not be distressed, he was stressed. Not being distressed and not sleeping. So it's much better that we could resolve his case in under a year, and then he could move. He was trying to get, he wanted to have this arranged marriage, and the bit where we were supposed to come back to court and run the pre-trials and things. And if you got convicted of any of those offences, you'd be going to jail. So then you're trying to get married and put someone in on bail conditions, and then if you got convicted, go to jail, which means you wouldn't be able to do anyway. So he had lots of personal issues going on, and for him, the best resolution was for us to be able to move on, get the best dates, get the fastest dates, move on, put pressure on the Crown, because we had a defence, we wanted to run it, we identified what that defence was early, did the research with the lawyers, we had the cases to try to run it, and it just kind of a little bit complicated, and then run pre-trials about those complicated issues to see what the rulings were, and there wasn't really much New Zealand case law or any on the thing that we wanted to do, and we were basing it on some Canadian precedent, and so it's quite important to have the pre-trial on that issue, because it was just kind of an unusual charge. So then just finishing off where we are, because we probably went on a little bit long, because we're at 31 minutes, sorry 10, and then of course you've got your trial memorandum, and then you're going to run it. So the evaluation showed that the pilot cases progressed more efficiently and faster, had fewer delays. The complainants were generally better prepared for the trial. They had reduced anxiety. The stakeholders, including the lawyers and the defendants, thought that the trial quality had improved, fewer adjournments, better evidence. The judges have been trained specifically on certain things, and the timing of the full trial dates resulted in more guilty pleas actually, because it was clear the time frame for things, and I think these evidential issues get sorted out so the client knows where they stand earlier as to where they're going to have a defence that's going to work to run, or whether they want to plead out and get their discounts as much as they can and get the best results.
And you eliminated sexual violence judges out. The only one I've been exposed to is just Judge Thomas.
Yeah, I had Judge Thomas as well, so and he's not the only one. They had about 16 somewhere, I think.
16
but
maybe a special course to the...
Yeah, I'm not 100% sure about exactly how many there's trained. I just couldn't hold that number.
Is it going to be rolled out in the rest of the country, or what's happening with it? Is there any...
Well, the report that I had from the 14th of August 2019 said, given the pilot's clear success, Judge Jude, she was still Chief Justice, determined that the pilot would become a permanent fixture in Auckland in one way at least. And all District Court jury judges would now receive the enhanced training designed for the pilot. And Judge Walker, who wrote the report, expected all jury trial judges to adopt the pilot's guidelines. And they considered that it was desirable that all lawyers avail themselves of the education and training in this area, and there's been some new guidelines for prosecutors developed by the Solicitor General in respect of prosecuting sexual violence cases, and they were saying that the Ministry of Justice was going to put some funds together for specialist training of Defence Counsel for the best practice in sexual violence courts. I don't know if you already did that. Or I can offer you 30 minutes with Judge Walker's report on the evaluation and the sexual violence court pilot practice notes. But sort of when I was in the court doing it, the first thing I did was to do the research to find out about it. I then found out the first case that the pseudonym was a special one, and I got the precedent from the Crown. I had quite a lot of discussions with the Crown. It sort of seemed to go on and on.
I mean, you're quite, but I think we covered the territory. What do you reckon?
I think we're doing a bit more. I'm not saying I'm great. What do you think?
All right.
Anyway, so at the point that the case had been...
So concluding statement from counsel?
I was right. Did I say 16 judges? I found it. But I couldn't remember these things. The fact sheet, pilot sheet, said there were 16 judges who were assigned the pilot cases, and there were 3 case managers. But of course, they've obviously upgraded things since then, because that was written back on the 14th of August 2019 about the sexual violence court. So, and obviously they still have the presumption of innocence. I think doing the research is really helpful to know what you're looking at, and then I sent my client a copy of these documents about what the guidelines were for best practice, the fact sheet that the court had produced on their website, and also I sent them an evaluation so that he sort of had some information about what he was looking at. And he didn't have any previous convictions, but he found all the research to be really quite helpful. Thank you.
If you enjoyed the presentation, tick the like box. Like.
Like and subscribe.
Thank you.